How and why can a registered trademark be cancelled or amended under Section 88 of the Trademarks Act? Let's begin by looking at the how and then the why, or the grounds on which an application can be based. Firstly, the how. Under Section 88(1), on application of an aggrieved person or the registrar, a court may make an order to cancel, remove or amend, or enter a condition against a registered trademark. What then is an aggrieved person? Aggrieved is not defined in the Act, and the courts have provided no single test to apply. In Healthworld Limited and Shin Sun Australia Proprietary Limited, Healthworld, the owner of the trademark Inner Health Plus, sought to have Shin Sun's trademark, Health Plus, removed from the register. Initially, Healthworld was found to not meet the definition of an aggrieved person. The High Court disagreed, stating that aggrieved should be interpreted liberally, but that to satisfy this, there should be a potential for the aggrieved party's business to be affected. Let's now look at the why. There are three broad groups of bases for an application under Section 88. Firstly, under subsection 2A, an application can be made on any of the grounds that the registration could have been opposed or rejected by the registrar, except that the trademark cannot be represented graphically. These grounds are set out in the Act, but an example is that the trademark contains a sign that is not to be used, such as the Australian flag. Secondly, under subsections 2B and E, trademark applications or registrations that were obtained or amended as a result of fraud, false suggestion or misrepresentation provide two further grounds. Now thirdly and lastly, let's take a more detailed look at Section 88 2C. Under this provision, a registration can be challenged on the basis that the trademark is, at the commencement of proceedings, so currently, likely to deceive or cause confusion. Importantly, this means the circumstances that are likely to deceive or cause confusion can have changed from those at the point of registration. So what then is likely to deceive or cause confusion? A mere possibility of deception or confusion is not enough, and there is also no necessity of demonstrating blameworthy conduct on behalf of the trademark's owner. In Campoamar Sociedad Limitada and Nike International Limited, Nike applied for the removal of Campoamar's trademark Nike Sports Fragrance. At no time did either company market goods in a similar category, and the court acknowledged that at the time of the trademark's registration, the Nike sportswear brand had not been used to a great extent in Australia. However, at the time of application to remove the trademark, the Nike sportswear brand was used to such an extent that Nike Sports Fragrance was now deceptive or confusing. So, in summary, let's just go back through the main points again. To cancel or amend a trademark under Section 88, you must 1. Be an aggrieved person or the registrar. 2. Apply to a prescribed court. And 3. Base your application on specified grounds. These are any of the grounds available for opposition or rejection of a registration, except that the mark cannot be represented graphically, that the application or an amendment to the entry in the register was obtained by fraud, false suggestion or misrepresentation, or that the trademark is currently likely to deceive or cause confusion.